Burney, who wrote a reference book on this particular subject. The states parties to the 1946 Convention have a common interest that the integrity of the comprehensive regime coming from this convention be guaranteed. So the court, as an organ of international law, has been invited today to guarantee the integrity of this regime and to take on board the contemporary international concerns regarding the conservation of whales. Let me now come, Mr. President, to the different parts of my presentation this morning. Now, firstly, I'm going to retrace the origins of the negotiation and adoption of the 1946 Convention. The idea here will be to demonstrate that conservation of whales was very early on the major concern of international relations. These concerns have evolved in such fashion that the first instruments of whaling regulation were seen to be inadequate, limited, and insufficiently comprehensive. As I say, inadequate, limited, and insufficiently comprehensive to fulfill the objective of conservation and recovery of whale stocks. Also, the regime of the 1946 Convention is in some ways different from the first instruments of regulation. In the spirit of the negotiators of the 1946 Convention, this convention was breaking from the logic of times gone by, codifying certain aspects of regulations that already existed, putting into place a new and real system targeting the conservation and recovery of whale species. Now, in a second step, I will look at the question of the object and purpose of the convention itself. At that stage, the objective will be to demonstrate first and foremost that the text of the 1946 Convention, read in the ordinary meaning of its text and in the light of its context, are sufficient in themselves to prove that the Convention has always had a conservationist function. There's no fragmentation of the object and purpose of the 1946 Convention as Japan would argue. It's an object and a purpose which are both comprehensive and aim at the conservation and recovery of whale stocks. That enables me to underscore another point. I will show that subsequent practice of the International Whaling Commission, the IWC, has continually advanced the importance of conservation in itself. This approach of the IWC, the International Whaling Commission, has certainly been dictated by the 1946 Convention, but also been dictated by general international law. Then, finally, I will underscore the collective framework of the 1946 Convention, the mechanisms, tools, and legal means enabling the realization of the object and purpose of the 1946 Convention have to be defined within the bodies which underpin the collective framework of this selfsame regime. So allow me, if you will, to revisit the origins of the Convention of 1946. One hears it said here and there that the questions of conservation of natural resources have only emerged very tardily on the international scene. A number of authors mention the end of the 60s. The court itself, in the Gabčíkovo-Nagymáros case, dates the preoccupations with environmental protection to the 70s. Now, the domain of whale protection is one of the exceptions to the rather inglorious late emergence of environmental concerns on the international scene. Very early, the international community was interested and concerned by the destiny of these biological resources, which are whales, very important resources for a number of ecosystems and threatened for many years now by overfishing. Indeed, as of the beginning of the 20th century, the necessity to regulate whaling emerged with the emergence of factory ships which enabled whaling to take place well beyond state territorial waters. Whaling regulations started within the League of Nations, and ended with the conclusion of the Convention in 1931 for the regulation of whale hunting. Already then, at that time, in 1931, there was an awareness of the exhaustible nature of whale stocks and of the necessity of putting into place a conservation system in parallel with commercial management and exploitation of whales. Of course, the idea of an economic exploitation of whales took precedence over other considerations, but the objective of conservation was present in the framework of the 1931 Convention. This last, that's the 31 Convention, failed in its ambitions of conservation because there was no real system of effective international monitoring of the whaling industry. Furthermore, it appeared very swiftly that over and above right whales, grey whales were also on the way to becoming extinct. That's why more severe and stringent regulation appeared necessary. Now, despite the disappointment that can flow from failing of international regulations, a major lesson was drawn from this unfortunate experience of the Convention of 1931. Conservation of whales, even for exploitation, economic exploitation, requires a collective, transparent and binding system of supervision. Now, whales weren't abandoned subsequent to the failure of the 1931 Convention. Their importance was such that in 1937 the regulation of whaling was going to undergo a new step forward via the adoption of the International Agreement for the Regulation of Whaling and the 1937 Convention. This agreement wasn't just about commercial exploitation of whales, as Japan would have us believe. Rather than taking a step backwards, the agreement of 1937 consolidated the conservation section of international protection of whales whilst guaranteeing the perennity of whaling industry. But the agreement of 1937 also very swiftly demonstrated its limits and its weaknesses. New concerns concerning excessive whaling and its negative impact on the recovery of whale stocks emerged within the international community. And a new legal regime was required to meet these concerns. This regime had to develop the collective framework of whaling regulation in order to reinforce the perspective of conservation and recovery of whale stocks